I want to talk now about some of the language changes that take place in this legislation and some of the things that we've done in bringing this thing forward. And these will affect how the cases go. One of the major things that we did was we've used, instead of using shared parenting, we use equal legal and physical access throughout this bill. That corrects a major conflict with the 14th Amendment Equal Protections Clause, with custody being awarded 85% of the time to a woman. This will give men a chance to be involved with their children. We know the statistics that support father involvement and their influence of it on a child's life and the benefits to society. Clear and convincing evidence becomes the standard of review. This corrects the use of discretionary decisions and requires the courts to use facts, not affidavits, as their basis for awarding custody. This will also eliminate the use of false allegations, which are a major problem for the courts and commonly used to take a parent out of a child's life. There will be automatic deviations on child support. A parenting time adjustment has long been sought out, and this will correct the situation for parents that have their children 50% of the time and are currently paying child support as if they only see them a minimum. This does not eliminate child support. What this does is makes the support amounts fair for both parents and makes both parents responsible for the cost of raising a child. This was a recommendation from the last Ohio Child Support Review Task Force. Guardian ad litems become a may instead of a shall, and costs are taxed equally. At present, the cost of guardian ad litems are not divided equally, burdening one parent with a cost that affects both parties. I have expectations that in the future the use of GALs will diminish greatly, and this is just an effect that will happen when this fully takes place. Psychological, medical, psychologic, and psychiatric exams are by written motion, and costs are taxed to the moving party or divided equally. The costs of these exams are very high. They're often unnecessary and are brought on by false allegations that are presently very prevalent. Often these are done now simply by verbal motion or suggestion, and they're done by attorneys just simply to drag these matters out further, often just to get a status quo established and continued. The courts are now going to have to support all of their findings by a finding of facts and conclusion of law, particularly when they reject a plan. This will have a far-reaching effect that's going to be a major benefit for everybody. And it's going to make life easier if for some reason a case, as we move forward on this, has to go to the appellate court. The discretionary standard that's currently used in family law in Ohio really gives you only one method of challenging that decision, which is to base it on an abuse of discretion. And with these discretionary decisions being so vague, um, now they're going to have to do what they've been doing all along, but it's, codified that they're going to have to do this. Um, if here's one that very few have seen, and this is a new one that we're going to bring in, and that's if a court awards less than equal, they will have to set up a plan of action so that unsuitable parents can remove the unsuitability. I use the example that it's currently easier for an unfit parent to be reunited with their child than a fit parent that goes through a divorce. Um, this method is used in juvenile courts and in children's services cases all the time. It's going to be a first for the domestic relations court, but it will not be a burden on them because of the fact that we're working with a lot of blended courts now that are working on uh, doing both these type of cases. Um, it also gives a parent that has a problem a chance to correct the problem and get themselves back involved with the child. Um, this will really help in the long run. I mean, obviously, we do not want an unfit parent involved with the child, but if that parent can remove those barriers, then we need to get them back involved with the child because of the benefits to the child. The use of child support as a method of blocking equal access is addressed now as to in this by considering whether or not the parent had the ability to pay. Um, this is one that few know is within current law. Often we have parents that fall behind because of work issues or unreasonable orders. Um, the unions pushed for child support and custody to be a separate issue because of layoffs and plant shutdowns, which are often mandatory. These often created a situation where a parent was unable to pay, and same goes for unreasonable orders, which causes a person to be in arrears. Um, with these two issues supposed to be separate, why are we allowing it as a part of a custody determination? This one is common sense. The use of potential harm is removed. There's no more crystal balling by the courts. Um, I don't have a crystal ball. Judges don't have a crystal ball. They don't know what's going to come in the future. I certainly don't. If I did, I'd go out today, buy a lottery ticket, and be done. Um, that removal of this clause and procedure is part of the addition of clear and convincing uh, evidence standard and supporting those decisions with fact. We're going to allow older orders to be revisited and changed once this is signed into law. We've had a lot of parents that should have been with their children. There was nothing wrong with them, but the discretionary standards that are there today have literally blocked them from access to their children and just made them a visitor. We can't continue with that. As a society, we're paying that price. Temporary orders have always been a problem because it establishes a status quo for these courts. No more. We're going to have to start our temporary order process, and we're going to with this bill, by making it equal from the very beginning. Um, unless you have clear and convincing evidence that the other parent is unfit, everything is going to start. That's a major protection, and it's necessary. We can't have status quo establishing the system. It just doesn't make sense. The other one, and this is the one that affects the never married parents. Putative fathers will stand on an equal basis with a mother in the allocation of rights. Currently under Ohio law, there's a section that an unmarried mother has all the rights to the child. We can't have that. The increases in unmarried parents, numbers of unmarried parents, has gone up tremendously through the years. There are a lot of fine, never married parents, both fathers and mothers, that have been removed from their child's life. We've got to put an end to that. We've got to get everyone involved in their children's lives. That's the entire purpose of passing this legislation. Let's get this done. Even this out. Correct these societal defects and do this for the benefit of our children. My name is Ray Lautenslager. Organization is National Organization for Parental Equality. You'll see a little blurb that'll give you our website, which is nopeohio.org, and I can be contacted through that at any time. Should you have any questions, please feel free to contact me. I'll gladly talk to you about this. It is an important issue. We do consider this to be the model for change for the entire country, and it is going to, I'm confident we're going to get it done this time. I thank you.